meeting with the Department of Labor with the State Apprenticeship Agency last week. We're going to be doing some additional follow-up. But if you're on the call and you have wage schedule issues, if there's time at the end, I want to make sure that we capture those questions. And I'll talk a little bit more about the follow-up from that meeting and what's going to happen next. But for now, I'm going to turn it over to Kristen and welcome you. Thank you so much for taking time to be with us this morning.
Yeah, absolutely. Good morning. So I'm going to share my screen here so I can get, let's see here. And actually, hold on. If I put it over there, I'm not going to see it once I open. So 1 second. I'll be turning sideways the whole time. So when I put together what I wanted to talk with you all about today, it became very heavy. All right, Marilyn, are you seeing the slides or the notes screen?
I can see both.
You see both?
I can see, yes, I see both the larger screen and the smaller preview slide.
Okay, well, let me try that again. That's a strange one. Okay, we'll do this. I'll share now. All right, how about now?
Got it. Perfect.
Okay, might be a little out of practice, right? We were doing this every week during COVID. So when I started putting this together, I realized there's a lot, and I'll share this, these slides, Marilyn, I'll send them to you and Holly afterwards, because there's a lot of information in it, but mainly it really became an employment legislative update because there's just so much that happened this year and just kind of little things to be aware of. So didn't get so much into the OSHA side, but if you've got specific questions on things, happy to take those at the end if we'd like, but happy to take them as we're talking through these, any questions you might have. So, oops, let me see. Yes. So the first thing, I'm going to jump right in here because like I said, there's a lot of information in these slides. The first one I want to talk about is the Power Act. And this is one where your lobbyists for IECRM were even, fighting against this. I think everyone was. It's actually been proposed the last 5 years, hadn't passed. It got watered down a little bit. But there's still some significant changes that I just want everyone to be aware of. And these are kind of the 5 areas that we're going to talk about that power changed. And particularly when I say confidentiality agreements, this is going to apply to separation agreements and severance agreements. So if you're still using a severance agreement that you've had in your system for 5 years, it's not going to be compliant anymore. So just, keep that in mind when we get there. But these are the areas we'll talk about that, have changed for you to be aware of based on power, which is currently in effect. It passed and went into effect in this summer. So first, it expanded who's protected in Colorado. So when you're looking at your handbooks for next year, we always recommend having that catch-all of any and all protected categories, but just be aware marital status has been added as a protected category. And, I will say, as much as that seems like an odd protected category, we actually had 2 charges, EOC charges. They were actually in Utah, not Colorado, based on marital status. And they were actually from men claiming that because they had children that were in one of them specific claim was because the children were in the background of Zoom meetings, he was being retaliated against by his employer. So, keep in mind that these claims do happen, but that's now a protected category in Colorado. There is a carve out for small employers. So the act makes it discriminatory, unfair employment practice to discharge, refuse to hire, promote based on someone being married. It does not apply to those with less than 25 employees. But even if you're a small employer, if you're doing your annual update of your handbook, it doesn't hurt to put that in there, but just understand that is how at least it was written. And a lot of times these concessions are made when they're trying to get these passed. All right, one of the things it does on disability discrimination, this one's not going to affect your day-to-day very much because essentially it's just bringing the state disability discrimination law more in line with the ADA. So the previous text talked about that if there was no reasonable accommodation and the disability has a significant impact on the job, So, essentially what would happen is that it was not an unfair employment practice if you could not, hire someone or promote them, or, a lot of times it's bringing them back from leave. And it originally had talked about if there was no reasonable accommodation and the disability has significant impact. So now they've changed it to essentially provide if there's no reasonable accommodation, and it just goes to that would allow the individual to satisfy the essential functions of the job. That's essentially the test that we've been recommending employers apply anyway, because that's more in line with the federal law. But for really small employers that maybe you fell under the ADA or did not have to fall under the ADA, that you could look at the impact on the job that the disability might have. So that no longer exists even on the state level. So with CADA applying to all employers, even your small employers in Colorado, your test now is there, you're going to be analyzing, is there a reasonable accommodation that would allow that individual to perform the essential functions of the job? That's what you're looking at. And like I said, we run into it a lot with employers when we're looking at, do we want to bring someone back after they've been out for injury, work related or not work related. So just keep that in mind, that this impact on the job is no longer part of your analysis. And I think I said, if we have questions as we go along, just feel free to come off the mute or put them in the chat. Either way works. All right. One of the big changes that we saw here was the change in the definition of harassment. And this is the one that as employment lawyers, we were pushing back on pretty hard because it just changes a whole body of case law. So the old definition that we had is what you see here on this slide. Harassment means to create a hostile work environment based on their protected class. Harassment's not an illegal act unless you have a complaint filed with the appropriate authority and they fail to take a reasonable investigation, take prompt remedial action. So that's kind of how we defined it before. So the Power Act has amended that definition and made it broader, if you will, because now what it says is that harassment or to harass is to engage in and welcome physical or verbal conduct, written, pictorial, or visual communication directed at that individual because of their essentially protected class. Now they've added a subjectively offensive component. Now it does have an objective component, so it's not just if that person feels that they've been offended, but it talks about so subjectively that person was offended, and objectively a reasonable person would also be offended. But this is, the body of law that changed. The communication or conduct need not be severe or pervasive. So that was, typically when we were looking at harassment cases, what we were trying to determine was it severe? Meaning, was it one incident that was so severe it could be harassment, a rape in the workplace? Or was it so pervasive that it became harassment, right? So it's not just that one day my boss told me a racial joke. It's that, every day I was subjected to racial comments. So now that severe and pervasive is gone. We'll have to see how this plays out in case law, because like I said, this is the federal standard, is severe or pervasive. All the, case law has been built around these words. So, Colorado is really putting itself out there, getting rid of those words. We may start to see more harassment cases, especially those who are trying to test as to what this language means. But essentially, something to be aware of, that if you receive a harassment complaint, and you're going through your internal investigation, this severe and pervasive isn't the standard anymore. So you may end up with more behavior that you are calling unwelcome if you think both that person and another reasonable person would be offended by it. So it may make it a little broader in your analysis. So I'll pause if there's any comments about that. This was one of the changes that we may not feel right away, but as case law starts to develop, we'll have to see kind of what the judges do with it. And I got one more slide here. A couple more on harassment. So what they tried to do was kind of the compromise was, okay, well, if we're going to take out severe or pervasive, how do we then define what this unwelcome conduct or communication is? So they tried to give some examples. So the submission of it is made explicitly or implicitly a term of their employment. Objection to rejection of the conduct is a basis for the employment decision, right? So, I refused my boss's advances. I lost out on the promotion. The conduct has the purpose or effect of unreasonably interfering with my work performance, or creating a hostile work environment. So these are, to me, these are more kind of obvious examples that likely would have been considered harassment even under the old definition. Here's some more. They're trying to define it: the nature of the work or frequency of the harassment that occurred in the past is not relevant to whether it's discriminatory, right? So that's, striking down that severe and pervasive. So this is the second paragraph here is what they, kind of tried to put in the law to have some kind of standard a little bit, stating petty slights, minor annoyances, lack of good manners is not harassment. Although, here's an unless when taken individually or in combination and under the totality of the circumstances meet, the standards that we saw back here. So, oh no, sorry, not that, forward. Again, I think it's made this harder for employers. I think we're going to see test cases come out in Colorado as far as, what does this mean? Judges are going to struggle. They've been applying severe and pervasive since these laws went into effect. Now they're going to be looking at, the totality of the circumstances. Here's some factors that they put in the law to try to consider totality of the circumstances. So there is still some frequency, duration. Was it threatening? Was this humiliating? I mean, it's, I hate to use the word squishy, but it is squishier now, I guess. It's, I think it's going to be a little easier to bring these claims. So again, something to keep in mind if you have harassment that gets reported to you. There is still the affirmative defense in the law. So you as an employer, your defense to a claim that a supervisor engaged in harassment, but it is pretty well defined. And so when you do your investigation, make sure that, you're checking these boxes. So you have a program that's designed to prevent harassment. So we have a policy, we train on it. We have a way to report. I like to have a more than one reporting structure. So, that way they can't say, well, I didn't report to, this one HR person because she was actually the problem. So you've got more than one reporting. So, we've got a good program. You take prompt, reasonable action to investigate, right? So each time someone reports harassment, you're going to investigate it. And you take remedial action in response to the complaint when it's warranted. So we're going to investigate and we're going to document what, if anything, we found and what we did. This communicated the details. Not only do we put out our policy or program, I like the idea that we're training employees on it. And we document that and we have training sign-in sheets. So, similar to how, on the safety side, you're going to document that employees go through respirator training or log out, tag out training. To me, this becomes just as important because this is the only way to assert this affirmative defense, that you did everything you could to prevent it. Because we want to show that the employee unreasonably failed to take advantage of it, right? So, we see a lot of cases where employees, I've got one right now on appeal, an internal agency appeal where the employee did not report harassment until after she was terminated. And so, it's kind of showing, look, we had all these policies and programs in place and people knew about them and we can show past good action. So, keep this in mind with, in trying, when you're, you get those complaints and making sure that you document your steps. Any questions on kind of these changes on the harassment side? Like I said, I think this is one that you're not going to feel right away, but we'll see what comes of it as the case law develops on it. Okay, so non-disclosure agreements. So one of the things that Power changed, and this includes a confidentiality clause. So you may say, well, I don't have my employees sign it, what we traditionally think of a non-disclosure, which is true. Remember, we're not getting into today, but Colorado passed that law, passed a law earlier this year, making it very difficult to have non-competes, which is sometimes what we think of with a non-disclosure. So separate from your non-competes, which are very limited now as well. But essentially under power now, it makes a provision in an agreement where if you're limiting the ability of the employee to disclose or discuss any alleged discriminatory or unfair employment practice is void unless these steps are followed. So this language is broad. Through the Colorado Bar Association, labor and employment lawyers, we meet, and one of the things we've talked about is that, pretty much everyone agrees that this makes this apply to confidentiality clauses in settlements or severance agreements. Now, one of the workarounds we've been discussing in our office is, well, what if, on our confidentiality clause, we put some language about, this clause is not intended to limit the ability of the employee to discuss an unfair employment practice, because let's say it's not a settlement agreement, it's a severance, right? So employee, you're going to let an employee go, you're giving them severance, you want a release of claims, and so that one, potentially we put some language in there that we're not limiting the ability to discuss an unfair employment practice because there's not been one asserted. That one makes me feel a little less, not as nervous to not follow all these steps and kind of put this language in. But with a settlement agreement where someone's asserted an unfair employment practice, I don't have the same comfort to limit your risk, right? So like I said, this new law has not been tested yet. And so if you want to avoid any challenge to that confidentiality clause, then you follow these steps, which means it's mutual. So we have a mutual confidentiality clause, both employer and employee are restricted. You specifically put in this exception for just, that they're not prohibited from disclosing underlying facts of alleged discriminatory unfair employment practice. Disclosure of the underlying facts does not constitute disparagement. So based on that, we've been putting a clause in, if you have a non-disparagement provision in your agreement, we've been, to be on the conservative side, making the non-disparagement mutual and carving out this exception as well. Now, this is something that we've added into our separation agreements. If there's a non-disparagement clause and the employer, it disparages the employee. So it doesn't have there's no punishment if the employee disparages the employer other than what's in your agreement. Then the employer may not seek to enforce the non-disparagement or the non-disclosure confidentiality or seek damages against the employee for violating them. So if you put a non-disparagement clause in your agreements and you as the employer end up disparaging the employee somehow, then you cannot seek to enforce either the non-disparagement or the confidentiality provisions against the employee. A lot of employers are opting to not include non-disparagement. I can't fault that, frankly, because, we don't see a lot of enforcement afterwards of that. But with social media, some employers want it because you want that at least deterrent effect. If you put in liquidated damages, so if the employee violates this, he or she must pay X amount, reasonable, right? So there's not a limit. We don't know what that means yet. Typically, it's been found that if you say the employee forfeits the entire settlement amount, that's usually been found not to be reasonable. So we're looking for a different amount there. And then there's addendum that both the employer and employee sign that this agreement complies with the Power Act. So what we've done on our separation agreements is we've actually tacked on a separate page on the back after the signatures that both employer and employee sign, attesting that this provision or this agreement complies with Power. So what this has done, it's made separation agreements probably a page longer, right? They were already 6 or 7 pages. It's made it longer because if you want confidentiality, then we've got some hoops to jump through. If you want non-disparagement, we've got a couple other clauses to include. But either way, right? So if you want confidentiality, you've got to follow, and you want to be on the conservative side. We don't want risk, and we want to make sure this holds up. We'd recommend you follow power and include these in your agreement. So that's why I said at the beginning, if you're still using a severance agreement or a separation agreement that may be a few years old, they need to be updated, especially depending on what you want in those agreements. We've also been adding some language in to address the NLRB decisions that have come out against having confidentiality in agreements. The NLRB's really pushed back on any kind of confidentiality in settlement agreements. And so we've crafted some language to try to address that issue. So again, confidentiality is definitely under attack, both the federal and state level. So there's ways to draft around it and still have it in agreements. But just understand there's language needing for that. All right. I know that is a lot of information. The other one is making sure, as part of power, is that you've got to have a designated repository for all written or oral complaints of discrimination and unfair employment practices. This must be maintained for 5 years. This is what it needs to be in the complaint. So if you get an oral complaint from someone, you need to put in, draft up these documents. We've already heard from plaintiffs' attorneys, that in litigation, this is going to become an absolute request, right? So when they request documents, they're going to request it for 5 years. And all written or oral complaints of discrimination or unfair employment practices, because they know based on power, you're required to maintain that now. Oops. So keep that in mind, that make sure that you've designated who's doing that and where you're keeping it. So if you find yourself in litigation, you can show that compliance. Some other record keeping obligations. This is also 5 years. So it's personnel or employment records. So any requests for accommodations, obviously complaints of discrimination, application forms, other records relating to hiring or promotion or demotion, and records of training. So, these are documents that, when you get those requests, which are pretty typical when someone's filing a charge, that they want a copy of their personnel file. These are the kind of documents they're going to be looking for. So we recommended, turn off that automatic record deletion, or, set this for 5 years, making sure that, you're keeping the records that are required. And because now that it's in this law, people are aware of it, and, they're going to be asking for it when we get to litigation. All right, before we switch to the equal pay for equal work, I want to, pause. So that was power. So now you can understand why they've been trying to pass it for 5 years. It never passed. Why we were pushing back so hard, because it's a lot of changes coming, and none of them favorable for employers at the end of the day. So that's power. So let's move to the equal pay. This is actually a good change. So that I can tell you about. So, we've talked on this group and committee for, a year or two now about equal pay and what it requires. And one of the hardest parts of the equal pay law was what they had called these opportunities for promotion, or promotional opportunities. And how do we post promotional opportunities, right? So we had these, what we were calling kind of butt in seat promotions, but now the law is calling career development or career progression. And you were having to post those before somebody got progressed in their career with their salary. So they have taken those out of what has to be posted. So let's talk about that. So first, there was here, at least they did this is an employee concession, allowing a plaintiff to obtain relief going back 6 years for back pay, not just 3. So that is a huge time period. So keep that in mind. So starting January 1, 2024, it amended what you're posting, what you have to post. So the distinction, I'm going to drop down this second bullet here. Job opportunity is what has to be posted. that no longer includes career development or career progression. So let's talk about those kind of two exceptions that we have now. So career progression is a regular automatic movement from one position to another based on time in the role or other objective metrics. We ran into this with a client. They have a lot of investment brokers. So, they have all these tests that they take. And so I'm, agent 1, I take my test, I become agent 2. I take my test, I become agent 3. So they were really struggling with how do we post that? Because this is just this person's own career progression, that if and when they choose to take the test, they move up a level. That's an objective metric, right? I take a test, I move up, I pass the test. That to me is career progression. Now doesn't have to be posted. Similar, career development does not have to be posted. So this is where you change my term of my comp, my benefits, my duties, maybe my position, in order to update my title or compensate me to reflect work performed or contributions I've made. So this is where, again, I'm just developing my career. I've been performing really well in my job, and you're going to move me into, the next level position. So don't make these too broad, right? So I'd still be cautious, not defining them too broadly in your organization, but just keeping in mind that at least there is some room here that you're not having to post somebody's career progression. So still, though, with open job opportunities, what you're supposed to do is post it, obviously, with salary and benefits. And now they want you to include the date by which you anticipate the application window closing. So that's a new addition. So in addition to the comp range and benefits, you're supposed to, put, applications for this new position. Our new CFO is going to close on Friday. This is a new ad, and this is something I want to make sure everyone's aware of, because this is one that I wish they'd not added. So within 30 days of selecting a candidate to fill a job opportunity, so a new position or an open position, you must make reasonable efforts to announce the name of the candidate, that person's title, and how other employees may demonstrate interest in similar job opportunities in the future. So making sure that people understand who it is, who filled it, and how they could apply in the future. Now, this is one, we're back to using career progression, right? So this is one of those, the career progression that you're not posting, but what the act now is requiring you to do is making sure that the requirements for career progression have been disseminated to all employees, and that those positions, comp, benefits, duties is out there. So similar to what I've kind of called a static posting before. So if I want to go from agent 1 to agent 2, here's what I need to do. I need to take this test. I need to pass it. I need maybe score a 20 or above. And if I do, here's what my new comp is. So they just want that information to be out there, so that way all employees would have the opportunity if they want to do that. That makes sense to me. I don't think any of us, I think all of us are fine with employees who want to progress in their careers and move up objectively. So that one doesn't give me much heartburn. All right. That's equal pay for equal work. So flipping over to HFWA, which we talked a lot about the last couple of years, the Healthy Families Act.
Kristen, can I ask a question?
Yeah, absolutely.
Just on the previous section, I put in the chat that in the career progression piece, just for everyone on the call that works with our apprentice community, this seems like it applies to an apprentice's progression as well. So that because that was one of the issues, was as an apprentice moves from first, second, third, fourth year, right, as an apprentice gets licensed to become a journey worker. We were having some of those questions for clarification early on about, well, do you have to post that, I'm now going to pay them more because they got a residential wireman's license, or because they got their journey workers license, etc. I think that applies for clarification for our contractors, that it's part of the career progression, but publishing the career progression around what's required for education and training over the course of the 2 or 4 years to attainment seems like that would meet the intent, right? If you're saying this this is what the career
Absolutely.
path of an electrician looks like.
I agree. And that to me is a great example of, yeah, what is now excluded from these job postings. Because you're right, because it made no sense that when somebody passes their test, we were having to post, because we're like, that's not a position. So yeah, like I said, this was a
Right.
big change. This is one of those where I think business got active and let the legislature know, hey, this doesn't work for all positions. And so yeah, so I think for the apprentice, when he reaches those, that'd be called career progression, just making sure you've posted somewhere how someone does that. It could be an intranet or wherever that's posted. And nope, I think that's a perfect example. And I know I didn't have the chat open, so no wonder I was missing those. I had a question from Pinnacle about, does the 25 employees or less pertain to all these rules? No, the 25 was just on that marital status. So that very small part for the power rule. So sorry, I missed that earlier.
That's okay. And sorry to interrupt.
No, you're fine. I'm glad you did. I said I'm happy to take it. Well, and the chat was over here on this screen, so that's why I would. But I have it open now, so I can see it now. So if we get more questions, okay. Sick leave. So we're all probably very familiar with these qualifying reasons, right? These are the ones we've been looking at since Healthy Families in the Workplaces Act passed a couple years ago. Or actually probably 3 years ago now. You should all have these in your handbook, making sure this is the 48 hours of leave, that all 48 hours of sick leave that all full-time employees in Colorado are required to get moving forward. That COVID did not change that. It's prorated for part-time employees, but they still have time as well. So the legislature added, and this was effective August, some additional reasons. And the big one here is bereavement leave. So many of you may have a bereavement policy. You may decide not to have that anymore. You can have both still, but an employee can now use their HFWA time to attend funeral services. And you'll see this is broader, or deal with financial and legal matters that arise after the death of a family member. A couple others here: care for a family member whose school or place of care has closed due to inclement weather. Right. So we're not just talking public health emergency. We're talking snow days in Colorado. Where does this apply? My kid's school closes because of bad weather. I need to stay home. I can use my HFWA time. Or if I need to evacuate my own home because of loss of heat, loss of power, whatever it may be, or other unexpected events, right? So understand these are broad. So, many employers maybe have taken the position, hey, if they have HFWA time, whatever they want to use it for, fine. But just make sure when you're doing your handbook updates, if you have outlined the reasons they can use it, that you've added these in. Just a note, so we all remember that the supplemental leave expired in June of 2023. We were the last state in the country to still be doing COVID leave, but it finally expired in June. So there is currently no supplemental leave out there. It's just the 48. But this law stays part of your policy. So we've been asked, can I remove that? But the entitlement to public health emergency supplemental leave is now part of HFWA, is now part of our law in Colorado. So we recommended you keep that in your handbooks, because there is a notice requirement. Keep it in your handbooks for your employees that state, in the event of a public health emergency, if you don't have 80 hours of leave, you'll get supplemental leave. So, there's ways to wordsmith it, but understand this is a permanent part of our law unless HFWA gets amended, that if we find ourselves in another public health emergency, it does kick in supplemental leave. Checking my time. Okay. So Job Application Fairness Act, just want to make sure really quick, this becomes effective July 1, 2024. You cannot request or require an individual to include their age, date of birth, or dates of attendance or graduation from an educational institution on an initial employment application. That's the key here, that initial application. I mean, we all remember taking off the box of, have you been convicted of a felony, right? The in the box. This is similar. Now, you can request copies of the transcript. so they can prove they went to school, but you have to notify the individual. They can redact their age or date of birth. You can request the individual verify compliance with age requirements that are bona fide occupational qualification, or if there's a federal law, or a state law, so teachers, right? So you've got to be a certain age, or something like that. So this is enforced by the Colorado Department of Labor and Employment. There's no private right of action, so someone can't bring their own cause of action, but they basically would make a complaint to the state. The state would then investigate and decide if they're going to issue you a penalty. So just check your applications. Don't be asking people how old they are or when they graduated. Until unless there's a reason for the job requirements, that you've got to do that. And obviously, let me see. Obviously, if there's something, on the federal side that requires age, then that's going to override this. Oh, here we see. One question, can the employee bank the sick pay, or is it to be used as work is being missed for the qualifying event? So back to the HFWA. So that's a really good question that we've been getting a lot, because you're right. What we've had employers ask is employees will call in and say, oh, no, I don't want to take my sick leave. I just want to take this day as unpaid. You can write your policy that, if they're taking leave, if they're calling in for a sick day, that they have to use their HFWA time. Otherwise it falls under your attendance policy. It's interesting if they're using HFWA time, it cannot count against attendance, right? But if they are trying not to, then it counts against your attendance policy, which then, becomes a disciplinary issue, right? Like, how many days do you allow someone to call in and take days off if they don't actually have leave to use? But you can write it such that, when they're calling in for a reason that qualifies under HFWA and the time is available, they have to take it. So just, keep that in mind. Marilyn, do you have a question on the apprentice date of birth? Oh, yeah, that may be one that could be an exception, right? Do they have to have certain ages on that?
Well, the question that I have is that under the new state apprenticeship agency requirements, they are essentially mandating that we include Social Security and date of birth information, which the U.S. Department of Labor let us not, that wasn't a requirement to put it into the Rapids database system, but now under the new state apprenticeship agency, we're being required to include Social Security number and date of birth. And so that's not necessarily for them to be an employee of ours. It's for them to, be tracked as an apprentice. But I'm just curious to know whether there's any misalignment in this law if we're being required, which means that we have to get their date of birth from the employee, from the employer, in order to be able to enter the information, because we don't know it unless the employer provides it to us.
Yeah, no, it's a good point. To me, that would be one of these where, like, I wouldn't, as the employer, I wouldn't have it on my initial application. But yeah, when you get to the second part, that to me becomes they've got to verify its compliance with a different state law or state requirement. Even. Yeah.
Gotcha. If in fact that's the state requirement, like we're sort of pushing back on, what do you need all this data for, right? What do you need all the specific information for, when we've been allowed to not enter it in the past? So just a clarifying statement, educational for me.
Yeah, Thanks. No, absolutely. Yeah, no, and you you would not be their employer, so you could ask, but if you're saying if you have to get it from the employer, they have to ask. But yeah, to me, that clearly, if it's being required, is going to fall in an exception. Yeah, for this. All right. And the last area I know is a lot of information for you today. As I said, when I put this together, I was like, my goodness, there's a lot of changes. And I would have never guessed we had this many changes coming from 2024. But what we have here is family. So most of you hopefully have all been making your withdrawals and deductions this year. So I just wanted to highlight a few things on family because benefits start January 1, 2024. There's quite a bit of overlap with FMLA, but not 100%. So there are reasons why someone could take family leave that may not be FMLA leave. It is 12 weeks of paid family medical leave funded through this payroll tax. There can be up to an additional 4 weeks for pregnancy or childbirth complications. It operates a little bit like unemployment, right? As far as people apply to the state to receive the money to get, so for you, it's unpaid, paid through the state. It's covering all employers regardless of size. Very low threshold, right, for coverage. So if an employee earns $2,500 during the base period, they're covered. They don't have to earn $2,500 with you. It can just be in the state of Colorado. This is what it's covering, birth, adoption, family member, serious health condition. All of these sound like FMLA. You kind of get to safe leave, right? So this is broader than FMLA. You get to domestic violence leave. 12 weeks, right? So this can be based on a rolling annual year. It can be intermittent leave, just like FMLA. One thing you want to make sure in your policy is that you state that if the reason they need family leave is the same as FMLA, it runs concurrently, right? You've got to have that in your policy so these leaves do not stack. Because if you're subject to both laws, everyone's subject to family. If you're also subject to FMLA, you do not want them stacking 12 weeks and 12 weeks. So make sure you put that out there that they will run concurrently. Employees supposed to try to give you 30 days advance notice, but they don't have to. So understand that there's this reasonable effort, and otherwise as soon as practical, right? This language, again, squishy language, this isn't a hard 30 days to notify you. So the way that the state has said is that if an employee applies, they will give the employee, and the state will give the employer notice. I believe the regs say within 5 days of an employee applying. Benefits are a decision is supposed to be made within 2 weeks. I'm not going to comment on, wow, that's really quick for the state. So we'll see, but that's what the regs are providing for that time frame. Some of the employment protections, they've got this right to take the leave. There is job restoration if they've worked for you 180 days or more, right? This is similar language to FMLA, same or substantially equivalent. While they're on leave, you must maintain their healthcare benefits on the same terms. That means that if I am an employee and I'm paying $100 a month for my health insurance, you can require me to keep paying my $100 a month, but you've got to cover your part. Employer cannot count family leave as unexcused or use it as a basis for discipline. There can be lawsuits brought under this, and there's a 2-year statute of limitations unless it's willful, and then they can go back 3 years. Let's see here. One question we had is employers with 10 or less does not have to contribute the employer portion. That's correct. When does that 10 count happen? Yearly, monthly, or quarterly? I need to check that because I know the regs address that. And I want to say that it was written such that if you ever go over 10 throughout the year, you trigger for the withdrawal payment. But Marilyn, I'm going to make a note of that, and I can for Pinnacle here, and I can let you know because I have looked at that, and so I know there is language about when that 10 count happens, but it's not very favorable for employers. But let me make a note, and I will let you know on that one. Okay.
That's actually really interesting for clarification because you think about a lot of our contractors that might ramp up employment over the summer,
right?
But go down to, a more stable employment base at other times of the year. Although
right.
Not really for employers right now because everybody's so blasted busy all the time. But, but there are reasons why you might ramp up for a project.
And I was looking to see if I could quickly find that. If not, like I said, I will follow up on that because I know we've looked at that question many times. It's just not sticking in my head, which makes me not want to guess on that one. I'm looking here to see if I found that quickly on the 10. The employer to do. Nope, not finding that quickly. So I will look that up and find and determine that because because I
Right.
what was sticking in my head was it was 10 at any time of the year, but I want to confirm that.
And then there's another question about the definition of the FTE. There's another question in the chat about FTE.
Oh, here we go. You considered all full-time employees. Okay, yeah, and let me ask that. Let me find that out with how they're counting the 10. But it's all full-time employees. Make sure, okay. One of the question was, are owners employees required to pay FMLA premium? So Sherry, are you thinking for family premiums? So it depends. So being over 10, you've got the 50-50 split on your premiums for family that's going in. So you've got or you can pay as the employer the full amount, or the employee can pay their half, if that's what you're asking. But you can split the family premiums between employer and employee 50-50 if you choose to. And let me know if that answers that.
Yeah, and I was going to say we might want to include another link on, to the Department of Labor site, just to clarify, the place to go for making sure you're registered and following that new requirement.
Yeah, because they actually have put out, I was looking here to see if I was finding that on the count, because they've actually put out quite a bit of information on family. The state's actually done a pretty good job with their FAQs. Let me see here.
Yeah, and for everyone, while Kristen's looking at that, we are recording the session, and we will have we'll send out the recording with notes, as we always do, and we always include any links or additional resources that we've referenced during the course of the conversation. So all of that will be going out later today or in the morning.
Okay, yeah, let's see. They had a couple counts, but that was more of a nationwide count. How do I count nationwide employees? It is a nationwide count, but they weren't telling us if you were under 10. Okay. Coordination of benefits. So we put out an alert, a Fisher Phillips alert, kind of outlining, what coordinates with which benefits, because some overlap and some do not. So for example, if an employee's on unemployment, workers' comp, those don't overlap, right? So you're going to get one or the other. Now for family and employer provided PTO or paid leave, employees can't get both for the same hours. However, you can't require them to exhaust their PTO, their HFWA while receiving family. So you can't require it. So, family is like a 90% wage replacement up to a certain amount. So for your employees, they're probably not going to get 90%, right? Because they're a little higher paid. So let's say they get 50% of their wages. So employees and employers, so you can mutually agree and put in your policy that the employee can use accrued PTO while receiving family up to their wage. So they can't get over what they would have made. So let's do easy math. I make $100 a week. The state wage replacements gives me $50 a week. You and I, we can have in the policy that if we both agree, meaning you as the employer provide it in the policy and I want to take it, I could take $50 out of my PTO bank a week in order to make 100% of my wages while I'm out. I can't make more than that. But again, it has to be an agreement. So you can't force the employee to exhaust. And that's a big change with FMLA, because those of you subject to FMLA, usually we would, because it was an unpaid leave, we would tell employees, we'd put in the policy, you must exhaust your PTO before, at the beginning of FMLA. So I go out for 12 weeks of FMLA. My first 3 weeks are paid with my PTO, and then I've exhausted it. So keep that in mind, that under family, you cannot require that exhaustion. So I could take my 12 weeks of family, get my wage replacement from the state, and then want to take my PTO, either, when I return or on the front end. I mean, obviously, this is all subject to business coordination, but keep in mind, right, if you deny me taking it, could I allege retaliation? So that's why we say those benefits could stack. But you can have in your policy that they could take it if they wanted. So you want to track these requirements, right? You want to track the leave time, how much paid leave they have. Obviously right now we're not in public health emergency leave, thank goodness you're not tracking that, but making sure that you've got in your system that you're tracking leave and how much people have, especially because they can take it, they don't have to take it, when they're, meaning they can take their PTO with family as long as they don't go over their weekly wage. If that happens, you can recoup it, but before you do any kind of pay deduction recoupment, let's talk, right? Because that we don't want to buy ourselves a wage claim. That happens. All right, Marilyn. So that was what I've got for you. Like I said, I got a little follow-up. I went on that 10 count for family, and I'll get that to you. But yeah, it's a lot. I mean, it's one of those that, I always am like, oh, we don't, there shouldn't be many changes. And then you start to put together and you realize there's a lot of changes.
There's a lot. Thank you, Kristen, for that. Let's open it up for questions. If anyone wants to just unmute and ask a question, or if you want to put something in the chat. While I'm waiting for that to happen, I want to let everyone know that next week is National Apprenticeship Week. So we're going to be doing a whole series of celebrations and outreach about our apprenticeship program, starting with this Friday at 8, Friday morning or Friday all day. We are sponsoring the 99.5 the Mountain Radiothon, which is a fundraiser for Project Sanctuary. And Sam Gluck with APCO Electric is going to be interviewed at 8:30 on Friday morning on 99.5. So tune in for his live interview to talk about veterans powering the industry. Great opportunity for us to promote. We also will be promoting that day and in social media and in other ways a community open house at IEC next Thursday from 3 to 6 p.m. So if you know a potential apprentice, their parents, we're including high school students and others in the community to come for an open house next Thursday, the 16th. And on Wednesday, sort of carrying on with some of this policy and advocacy regulatory work that Kristen's just been talking about, at noon next Wednesday, the 15th, is our quarterly member lunch. It's our annual policy forum where we're beginning to talk about policy and impacts on the upcoming legislative session. So I encourage you to come and join us for lunch next Wednesday at noon. And then keep an eye out for the announcement about our holiday party and the annual Parade of Lights on December the 2nd. Those are big highlights for us coming up over the next month. And we encourage you to participate and be part of all of these celebrations of our apprentice community, of our workforce efforts, and coming together as an industry at our holiday party on the 2nd. One thing to note is that in addition to us having our float in the Parade of Lights for, I think this is the 6th or maybe 7th year, for the 3rd year in a row, all of the floats in the parade will be pulled by electrical contractors that are IECRM members. So all the floats in the parade will be broadcast live with being pulled by members of our IEC electrical contractor community. And I don't want to put anybody on put Brett on the spot, but there is a maybe possibility that if you are an electrical contractor on this call, that there might be one truck left for sponsorship. But don't hold me to that, because I haven't talked to Brett this morning and it might already be fulfilled. So it looks like we have some questions in the chat that have come in.
And Marilyn, I
and-
found that count here. So
Okay, great.
okay, so if an employer has 10 or more employees who were employed during 20 or more weeks in all of 2022, you're required to pay the employer share. So the way they're counting it is it does not matter. So the question from Corey about the full time, it does not matter the number of hours they worked. It matters if you, it's because it says, because they give an example here, and Marilyn will include this link when we send this out, because this is a small business guide, that it does not matter the number of hours they worked, just if they worked 20 or more weeks throughout the calendar year. So like here, they're counting seasonal workers. So to your point, like if someone gears up for a certain season, and so you have more than 10 for at least 20 or more weeks, whatever hours they're working, you're going to fall within, you need to be doing the employer withholding.
Excellent. It doesn't look like we have any other questions,
Okay.
but Kristen, thank you so much. It's always great information. You really are our special guest.
No
even when you
problem. Thanks
join
for
us
having me. I appreciate it.
We really appreciate it. Everyone have a wonderful day, and look for these notes to come out in the next 24 hours, and have a great week.
Great. Thank you.